Our next session, let's wait for people to get seated. Before we start, I'd like to acknowledge the arrival of the MLA, Dr. Margaret McDermott, who is the Parliamentary Secretary for Seniors to the Minister of Health. And I haven't had a chance to speak with her yet. But I did want to acknowledge her coming, and I thank her, and she's going to speak to us for a few moments during our lunchtime, so we'll look forward to that. We have three speakers here that are going to be talking about Bill 29, which is an overview of the changes coming on September the 1st, 2011. I know that probably all of you are really interested in hearing what these changes actually are and how they're going to impact the work that we're all doing. So we're really looking forward to hearing from Kimberly Asian again, who is from the PGT office. We have with us also Krista James, who is the National Director of the BC Centre for Elder Law, BC Law Institute. And she's got a project on potential undue influence she wants to chat with you about. And our very own, well, she's not ours actually, but she's the Public Guardian Trustees, but I like to call her our own, Kathleen Cunningham, who is the Provincial Coordinator for Vulnerable Adults with the PGT, and she's the part-time interim replacement lawyer by training with 20 years in financial sector dealing with the estates, trusts, and guardianship. She's the current chair of the what's probably becoming infamous collaborative that we've been talking about. So these three people are going to be sharing their knowledge with us today and bring us up to date on some of the most current information. So I'd like you all to welcome them, and I really look forward to hearing what they have to say.
Thank you, and maybe I'll just start by saying this isn't easy. Kathleen and I had long debates about how to prepare for this overview, and she won. She wanted a lot more detail in the slides, so basically what you've got is slides that have a good content of overview. There's still more detail behind this, but it's a good chunk of the detail about Bill 29 and what's coming in force on September 1st. I won't speak to all of it. I'll try and give just sort of the real highlights, maybe 20 minutes, because I know we're running a bit behind time. There are just so many little pieces that are gotten woven together in what we call Bill 29 that it's a bit challenging to know how to present the material, especially if you're talking to people that maybe need a revisitation of the current guardianship legislation to understand what's changing. All I'm going to do right now is basically talk about what's coming and what's new, and I'm not going to be going back over the existing legislation that we have in place. So, basically, Bill 29, what's coming in is pre-planning options and tools and safeguards, and it affects a number of acts, and these are listed here. Just for very, very quick context, as we mentioned earlier today, the adult guardianship legislation package, is a package of legislation, was dreamed up, passed but not proclaimed in 1993, had partial proclamation in 2000, several attempts over the last few years to bring it forward again. In 2007, Bill 29 was again passed but not proclaimed. It was to bring in the next sweep of guardianship, and it had the pre-planning component in it as well as the new guardianship scheme. But what basically, because of, I think, budget issues and concerns around the resourcing, the portion on guardianship has been deferred again. So again, we're sitting with a partial proclamation, the next step partial proclamation that's coming in on September 1st that largely addresses the pre-planning options and tools, plus some other tweaks that we were able to carry along with that, but nothing that is related to the guardianship scheme itself. So in other words, we're still with the Patients Property Act and comiteeship. And the other component that was in the original package, not Bill 29, but the original package, would have had consent to care facility admission brought forward too. That was called Bill 26 back in 2007. But we're still waiting on care facility admission legislation. So, just starting with the first, we thought the easiest way to address this is to go by act. If that doesn't work, tell us. This is our first presentation. So, what's new with enduring powers of attorney is that the existing Power of Attorney Act will now have a new Part 2 that's all about enduring powers of attorney, instead of the current legislation that just basically has reference to an enduring power of attorney. Now there's a whole section just on that that has a lot of extra safeguards. I've got a few slides here what you could sort of look through. One of the big achievements of this the EPOA is having a test of capability for executing a power of attorney embedded in the Act. Now that's a big one for the legal community, and I know there's a legal conference on tomorrow where they're going to be talking about this. The change is that there will no longer be what we called Rep 9s, Representation Agreement Section 9 for financial. That is currently in place and it will be up to September 1st, but as of September 1st, you won't be able to execute a financial Section 9 rep agreement. The only tool that will be out there for full capacity agreements will be an enduring power of attorney. Now that doesn't mean you can't still do a power of attorney, which is just an agency arrangement. But if it's a pre-planning idea that is to carry on after you become incapable, then that's the EPOA. There's clear... I won't go into some of these details here because it's a bit much, but there's a lot of extra safeguards, and we've got a few other slides here where I can go into it. I think the test of capability is a real biggie. I think that there are some other limitations and controls. For example, one that we just sort of highlighted on here is you won't be able to appoint a paid caregiver that provides personal care or services as your power of attorney unless they happen to be your spouse, child, or parent. That could be a little bit, we've been having a lot of discussions about where that might lead. Nothing says that the agreement becomes void if they become a paid caregiver, but what happens if you made an agreement in good faith and then later the person starts to be paid, and that would actually be a breach and be a reason for maybe some other arrangements being needed. And they can be effective right away as soon as you sign them. There's clear execution provisions laid out in the Act, so there's a lot of things that make it really clear where the legislation to date has a lot of fuzziness in it. We note here the execution requirements, also clear rules for termination. I highlight that because, again, our current legislation doesn't say when something might end or be suspended or would terminate. Under the new legislation, as of September 1st, the authority of a power of attorney, an EPOA, will actually end if the power of attorney becomes bankrupt or if they are charged with certain criminal offenses. Or the power of attorney themselves becomes incapable. That you would think that was common sense and there might be common law behind it, but now it's clearly in the legislation, which will make it a lot easier for folks like us that have to investigate concerns. We talk about grandfathering here. Basically, any existing power of attorney that's considered to be an enduring power of attorney, or any existing Rep 9 for finances, will be grandfathered over. The new duties and responsibilities of an EPOA will apply to the grandfathered agreements, but whatever you had embedded in your old agreement can carry forward. So in other words, if you in fact had a paid caregiver as your EPOA or rep, that could still carry forward. You just can't do it after September 1st. Okay? Now, another biggie on here that is at least a big issue for our office, maybe that's why it's big for us, is it makes it very clear that the power of attorney is not allowed to remunerate themselves unless it's clearly expressly in the agreement, and they can't give gifts or loans, again, unless it's clearly in the agreement or is of a modest amount. And the Act actually lays out what the amount is. So we think of that DORA example. There was a request for the power of attorney to go and take some money out and make a gift for $5,000 to a grandchild. In fact, that might not be allowed under the new scheme. There's a cap of 5% or $5,000 annually total. So if there had been any other gifts, or if that $5,000 actually represented more than 5% of DORA's assets, then the power of attorney would be in breach if they made that gift, even if DORA was capable and asked them to. Okay? That's of interest to us who have to investigate. So the protections here, the Power of Attorney Act, the EPOA, will now clearly say that any concerns can be reported to our office and investigated. Now, I almost didn't need that because I have that power under the PGT Act, but it, again, lays it out very clearly that concerns, if they're reported to us, have to be promptly reviewed. So these are all just the things that can be brought to our attention. Basically, we're looking at situations where the adult is not capable of revoking or canceling their agreement. And we just, in fact, had a meeting with BCC not long ago about if we get referrals for people who are still sort of capable but don't really know how to work through the whole system, because there's execution requirements for revoking that could be a bit complex for someone, that's something that BCC might be able to help with, which is great. Okay, rep agreements. Basically, I've already told you about Rep 9s being, for finance being removed. The other tweaks in the Rep Agreement Act were really just to streamline the execution requirements and makes it easier and less expensive to set up a Rep Agreement. And I think that was, yeah, you can't require a rep agreement as a condition of service. They've put that actually everywhere: advanced directives, rep agreements, and powers of attorney. Okay, so PGT Act. There's been a few tweaks to the PGT Act for our investigatory provisions under both Section 17 and 19. Under Section 17, that's where we investigate. It expands it to clarify that we can, in fact, receive referrals and concerns about someone who's self-neglecting. Right now, if you read Section 17, it's all about other substitutes. Not that we don't take the referrals and work on them, because we have other powers, but now it makes that very clear. The other thing that's great is it makes it very clear. There's a line right in there that we can request information regarding incapability. So we've had for years doctors saying, what authority do you have to ask for medical opinions? That'll be clarified, and it strengthens our ability to protect the identity of someone who makes a report. Makes it more comparable with the health authority. Then our emergency powers, our protective provisions, have been tweaked again just a little. Not that we weren't doing it already, but it was a little weird thing. Like right now you read the protective provisions and it says we can take steps to protect the assets. So we could do a bank freeze, we could take steps to protect the assets, but it doesn't say that we can make any decisions or direct funds for the health and safety of the adult. So in other words, we could freeze the bank account, but we couldn't direct that, a couple $100s a month be given to the adult for food. So now that's been changed, and we were doing it already, but it just makes the legislation catch up with what the practice was, which allows us then to take protective provisions and keep in mind the health and safety of the adult. Okay. So the Adult Guardianship Act also has some tweaks, Part 3. Again, we don't have anything to do with the guardianship scheme, but the abuse, neglect, and self-neglect provisions of Part 3 have some very good tweaks in them. They, right now, the orders that you can go to provincial court for a support and assistance order are only of 6 months duration, 6 months with another renewal. That's been doubled to 1 year with another renewal. It's clarified that if all you're doing is going in for a restraining order against an abuser, you don't have to go through the issue of assessing the person of being incapable of accepting the service, and it allows interim restraining orders to be accessed more quickly without having to have the notice provisions. So we may see an increase in the use of the Part 3 court tools. Now, advanced directives, I'm just very briefly speaking to that. That's one of the new tools coming in, that you can create an advanced directive so that your physician or healthcare provider can follow that advanced directive without having to go to a substitute and get substitute consent if you're incapable. So the legislation around the advanced directives has all the execution requirements. It's basically very similar to a power of attorney. You have to have the same full competency. It needs to be witnessed. It's a very formal document. Now, what happens though is, I'll just go back. Sorry. One of the issues are if you have an advanced directive and then later want to create a representation agreement for healthcare, it makes it very clear which document prevails. And basically, unless there's some very, specific things put into the representation agreement, if there is a representative and there's an advanced directive, then the advanced directive cannot stand on its own. The healthcare provider still has to go to the representative. It trumps, if you will, and the representative then has to look at the advanced directive as guiding them as prior capable wishes. Okay? We are expecting forms, but we haven't seen them yet. The other change was it expanded the temporary substitute decision maker list from the current spouse, child, parent, sibling, anyone by birth or adoption. It actually puts grandparents and grandchild in the list, so that this list isn't a shopping list. You actually have to go to the highest ranked substitute. It adds in close friend, which is quite new, and person immediately related by marriage. Up to September 1st, if someone comes to our office, we can act as the TSDM or we can authorize someone, and we frequently authorize friends. So maybe going forward, the healthcare provider can just choose a close involved friend. The other thing that was a change in the Healthcare Consent Act is when making a decision, the way it was worded before made it really kind of problematic if you needed to make an end-of-life decision and you didn't have prior capable wishes to base it on. Now there's a new sort of definition, and it can be based on a best interest test that takes into consideration prior capable wishes always trump, but then current wishes, values and beliefs. Really, it's common sense. Most people wouldn't see that there's a change, but a legal organization like ours, when we have to be a substitute, we have to follow the letter of the law, and this actually just makes it more logical that you use a best interest test. They also have brought in some provisions to go into court when there's conflict and problems. So basically, just overall, what we expect is we've got more advanced planning tools. I'm thrilled that there's going to be real clarity around powers of attorney, when an adult can make them, who can act, and the duties that they are expected to work under. There's some nice tweaks to the Representation Agreement Act in order to make it a little cheaper and faster for people to be able to set up. And advanced directives are something that a large group of people were wanting. I think particularly the end-of-life scenarios. So that I guess that'll be the next step, see how well they work. And we're still waiting for the guardianship scheme. What can I say? Okay, thanks. Sorry, that was really fast.
That was good. Thank you, Kimberly. That it was fast, but you know, we've got the little slides and we can go back and look at them, and sometimes I find that it's really hard to absorb legislation and changes in legislation. I need to know where it is, and when I need it, I need to be able to find it, but I'm not a lawyer, so I don't absorb it very quickly. So anyway, thank you very much, and I know we've been waiting for that, and we'll be waiting for more as it comes on. Our next speaker is Krista James. And Chris, do you want to do it there, or do you want to get up here? Either way.
I'll come over there, too.
You'd like to come over here, too. When we were organizing this morning, we thought everybody would like to sit, and nobody wants to sit. And I can appreciate that, because it feels better when you're standing, I think. So Krista James is the National Director of the BC Centre for Elder Law, BC Law Institute, and we really are happy to have her here to make her presentation. Thank you.
I was actually surprised to learn that a lot of people are like me, where it's easier to think standing up. Yeah. However, the problem is I'm often shorter and the microphone's in the wrong place. Can you hear me all right? Mm-hmm. Okay. So, Kathleen, are you going to drive the PowerPoint?
Sure. A new job.
Yeah.
Driver of PowerPoint.
Kathleen produced these particular slides at about 10:30 last night. So, but she's been working really hard for this event. So I'm just a couple things by way of clarification. So the organization, I'm representing two organizations in a sense, but the British Columbia Law Institute is the BC Law Reform Agency, so that's working toward changing the laws to modernize them to better reflect needs of people in BC, and also the Canadian Centre for Elder Law, not the BC Centre for Elder Law. The Canadian Centre for Elder Law is law reform, legal education, and producing legal educational tools focused around the needs of older adults. And we're kind of one of those anomalies where the national body is a part of a provincial body. Very strange, has to do with just the nonprofit structure, but the Canadian Centre for Elder Law has kind of a national scope. The BC Law Institute is focused largely on BC issues. And I'm here wearing the BC Law Institute hat. So the BC Law Institute has a new project on recommended practices for wills practitioners. Wills practitioners being lawyers and notaries. Kathleen, we're sort of doing this kind of together, but she's mostly driving, because Kathleen is actually on the committee that's guiding that project. So, can't even see the slide from here, but, the impetus for this project is another law. So we're actually not talking about Bill 29. We're talking about a different law. It's the Wills, Estates, and Succession Act. So it's a new law that's coming into effect shortly. We actually don't have a proclamation date. The changes that Kimberly was talking about will be taking effect September 1. We actually don't have a proclamation date for WESA. We expect it to be early 2012. We're still sort of keeping our fingers crossed, but the government has gone as far as to be working on all the rules, and they're pretty much in place to put everything in effect. One of the reasons why the BCLI has been doing a lot of work around moving forward with the WESA law is that the BCLI was for years and years and years involved in a research committee around modernizing the wills and estates legal framework, and the WESA is really the government moving forward with a lot of the recommendations that very robust committee came up with after many years of work. So we're really excited about this change. And the project I want to talk about for a couple minutes is a project that's about enhancing the capacity of wills practitioners, notaries and lawyers to meet some of the new sort of obligations under the WESA Act that we'll have. And we think of, this is not particularly a project that's exclusively focused on financial abuse, nor is it exclusively about about older adults, but we think this is a piece of legislation that has a pretty significant impact, if not directly, indirectly, on older adults in BC. So the big change under the WESA that has given rise to this project is a shift in the the duty of proof when undue influence is raised. So undue influence, that's if some other person is putting pressure on a testator to make some changes or put some specific provisions in their will. Historically, in the past, if someone had raised undue influence, then there's a significant burden to prove that undue influence has actually impacted on the will. Now the burden of proof has shifted so that if it's raised under the new legislation, Section 52 of WESA, if it's raised, and I think Kathleen has a slide specifically on that, do you? No? Okay. If it's raised, then the burden shifts to prove that undue influence did not affect the will. So that's a little bit of a shift that sort of recognizes the kinds of social contexts that can affect the creation of a will in a negative way. So this is this tool is being guided by a project committee. It's an interdisciplinary project committee. We have lawyers, social workers. There's people there's a very experienced gerontology specialist on the committee. I think there's a slide here with the list of all the committee members. I don't know if you can read it. Kathleen Cunningham here, she's one of the members of the committee. So if you have any really detailed questions about the project, I encourage you to approach her. And she said that she's willing to receive any inquiries about the project. We expect the purpose of the project, I should probably take a step back and say this, the real purpose of the project is to give some recommended practices for lawyers and notaries when they're drafting a will and they have these concerns about undue influence. So in a sense, it's building some of this teachings out there about financial abuse, elder abuse, social dynamics that might be red flags of elder abuse. It's embedding this kind of material into an educational tool for lawyers and notaries. So it's a legal educational tool that the BCLI is producing that has a lot of information that's really quasi-legal or social in its orientation. This educational tool should be available, I think, around early 2012, but there is going to be a draft tool that should be complete quite shortly. I think actually in about a month. And we're really interested in getting input from people who work in this area. Greg Blue, who is the senior staff lawyer who is leading this project, will be I believe he's going to be putting a draft version of that tool. You're nodding your head? Yeah. The plan is to put a draft version of the tool up on our website. So anybody who has thoughts or questions or input on the tool can send an email to us, and those concerns will hopefully be reflected in the final tool. Again, it's a really interdisciplinary project in its nature. It's very important to get lawyers involved in this, but non-lawyers are really key in making sure the rollout of this tool really reflects the complex nature of elder abuse and financial abuse. So I really encourage you to send emails. There's Amanda Brown is nodding her head. She's on the committee as well. If there are people in this room who are on the committee, feel free to sort of raise your hand. I think it's Amanda and Kathleen today. Yeah. I think that's kind of all I wanted to say about the project. Okay, great.
I just thought I'm the one who asked that this project be put on the agenda, so I just wanted to sort of reinforce why. To the point about the interdisciplinary, I think Amanda and Martha Donnelly have made huge contributions to this project because of their understanding of abuse and neglect and the undue influence and the pressure that gets put on people. And the relevance to this group and Bill 29 is that in the Power of Attorney Act and the Representation Agreement Act, people can actually make reports or objections to our office, the Public Guardian and Trustee, alleging that there has been fraud or undue pressure put on a person to make or change or revoke a power of attorney. So we're going to be looking at what does that look like. And then so again, people are going to need to look at, is there undue pressure, undue influence going on when something is being made? So I think it's just useful information, the red flags, the tools that are coming out while they're in the context of being used in the preparing of a will. I think they'll be relevant to the preparation of powers of attorney. They'll be relevant to people who are trying to analyze a situation before it gets going to try and decide whether there's undue influence going on. So that consultation report will come out with the drafts of the tools. If you'd like to be on the distribution list for that consultation, if you can send your request directly to Greg Blue at BCLI, or you could send it to me and I'll pass it on. And then, as I say, the tool's supposed to come out by the end of the year.
Probably it might be worth adding that. Can you hear me if I'm just standing here? Okay. You can just go to our website, which is www.bcli for British Columbia Law Institute.org, and look for this project under. If you did a keyword search, recommended practices. There's probably only about 5 or 6 BCLI projects on the site, so it should be pretty easy to find. There's a backgrounder. It includes project committee members and some other information on the project. So the slides that Kathleen was showing weren't actually part of the package that got handed out because they were produced so late, but pretty much all the information can be found in the background that's on our website.
And all of the materials are going to be posted after the session, so everything from today will be available electronically, and we'll let you know when that's posted.
Wow. Well, thank you very much, Kimberly, Krista, and Kathleen. And we've done so well that we've got a few minutes that we can have some questions. And I see Amanda and Bernie and Leanne at the front here from the panel that we had. And who else? Heather's back there, and Chris and Kimberly was on it. So if you have any particular questions you want to ask any of the panel members, I can ask them to come up and just stand here and use the mic to answer them. That work? Okay. And there's a mic. There's 2 mics actually on the floor, which because we're recording this, it's really important that you use the microphones. Otherwise, they're not going to record very well. So it's a bit of a nuisance, I know, but I think that it will work well. So I see someone with a question. Thank you. You'd think I'd planted you there. I didn't.
I know. It's a quick question, and I may have missed the answer, but I think somewhere in the presentations there was the statement that the new requirements will be applied to the existing powers of attorney and Rep 9 agreements. How will people know that? People with the existing. As a case manager, I'm wondering, will I be the one telling them?
Yeah, well, that's a very good question. It's one that we've been talking about at AGAPAC and some of the other groups. There has, I think the Ministry of Health is planning to do some rollout on the healthcare side of things and advanced directives, and we're working with like Pauline James and waiting to find out a little bit more on that side. On the financial side, certainly our office is going to be putting information up on our website as we land on things. I don't believe we've heard that there's any rollout of like a public education component, though. So I think it's kind of like spreading the word. But yes, as of September 1st, no more Rep 9s can be made. And there's going to be people that are going to be wondering about that. And any existing ones are then treated as though they were a power of attorney.
Just to clarify, my concern is déjà vu. Frontline worker, case manager, when adult guardianship came in, that was the person trying to articulate to the public right in front of you, often in the midst of conflict, family conflict, what this new legislation was, what it meant, and defining roles and so on. So that's where I think the concern is rising in me in a short period of time to September 1st. Yeah.
Did you want to speak to that?
Yeah. Good question, Anne, and I feel your pain. Everybody who's in the health authority probably recognizes that. Our health authority is working on tools for education for staff around these legislative changes, but we're not embarking on a huge public education campaign. So I think it quite likely is going to be similar to the AGA experience, where I think this time around we're going to do a better job of giving the tools to the hands of the case managers and the folks that are in the homes of these vulnerable adults. And because of that, you are going to be part of the strategy as, the agents of change around this knowledge, because you're going to have the knowledge and it will get exchanged with your clients. But we're not doing, as far as I know, the public education piece, but we are responsible for ensuring that you have the tools. So that capability and consent tool that we've produced in VCH, Providence Healthcare and Vancouver Coastal Health are working together this summer, I hope, to revamp that and have it ready for, incorporating all these changes in it. So at least you'll have at least one go-to kind of scheme that you can look at for some of these things.
Thanks, Amanda. Jane?
Yes, this is interesting because I know as a CRN coordinator, I get questions around rep agreements and when they're suitable and when they're not and whether we should be doing more training. And we clearly have, I think, in CRNs a responsibility to do some public education around that in the fall, if possible, if individual CRNs can do that, because it's not just health authority. I mean, to try to get further upstream in this process so that when it gets to Anne and others in the health authority, let's have the public educated a little better around what this particular change means. Because the question we often get, well, do you need a lawyer? Yes, you do if you're executing, but no, not anymore, because you must use a different tool for the financial piece of it. That's disappeared. So I guess my point is just that the BCA CRN may want to, inspire individual networks around the province to get the word out in their communities.
We'd love to, Jane. We'll inspire, and we hope that you can raise the funds within your community to carry it out.
Can I just add that you may want to keep your eyes peeled to the seniorsbc.ca site. The Ministry of Health is looking at putting on up materials there, particularly with respect to advanced directives. It's not up yet, but please do stay tuned to the seniorsbc.ca site.
Thank you. I wonder, Kathleen, can we get all these websites together and send them out by email to everybody? We have everybody's email contact.
I think maybe one of the takeaways that we can have is that we'll sort of collect the links to all the places we've talked about. Our website, as Kimberly said, will have information. There's the BC Association of CRNs, like all of the websites that may have resources. We'll try and compile that. And then I think going forward, we'll be having links on our website, and I'm sure the association
it would be
will
nice.
as well.
And as a follow-up from this session today, I know a lot of you have been asking for receipts, so we'll look after that in that email, and maybe we can just put all the sites and put everything together. That'd be good. Okay. Yes.
Sure.
Do you have to use it?
It's all right. I have a question for Bernie. I'm a lawyer here in Vancouver, and I saw your list of criminal code provisions that you had there, and I'm curious about the misappropriation of money held under direction. Would that include monies in a joint bank account, for example, that was placed there as a financial assistance tool on an informal basis rather than the donor having a power of attorney? So mom and dad give child access to the bank account, but the idea behind it is it's supposed to be used for their care.
Great question.
I'm going to be real truthful with you. You're going to get just the candid answer here and a very generic answer, because each case is really, really unique, and the investigators need to go through and see what the intent is of what was happening, of the actions that were going on. And if there, of course, like I say, being a lawyer, if the intent is there that to defraud or to steal from the elderly, that would be what would be forwarded to our Crown to make that decision on there, whether or not that would be a charge in that area. Does that help at all? It's definitely going to be, it's going to cause our investigator to take a look at that and figure out what the evidence is proving and looking in that way, yeah.
Okay, I don't see any other questions, but I do see a big lunch spread out there, so that's probably...
One
Is there? Where? Hi.
Just
from
one
Langley.
question. I have a background in child protection, so I've had that training.
And I'm really excited about the training you're offering now for adult abuse investigations and things. I just wanted to ask about some clarification about designated agencies, designated responders, and responder coordinators. And the role, in referring to these case example of Dora, the role of the facilities manager, it didn't fit for me that the facilities manager would be the one that would be talking to Dora and talking to her son. I thought that should probably have been a designated responder. Can you just clarify that, Leanne, please?
So the challenge with that is it's vague on what the care facility, because some are private and some are subsidized. That was interpreting that was an owned facility by Fraser Health, or the health authority. So designated agency, so the organizations, the 5 health authorities. Designated responders are the staff that each agency chooses within its organization to conduct the investigations. Now the term designated responder coordinator, that's been developed more formally by Vancouver Coastal Health to really be that kind of expert on site. Best example is in the hospital. You have maybe 50 social workers, but they all report to a practice leader who's the expert that they would go to for consultation and support throughout an investigation. In practical terms in care facilities, sometimes it's the very first person there. The other thing, if it's a financial issue that's come to their attention, their first, if it's a bill payment, they usually start to ask some questions first. They don't usually just refer it to the public trustee or the health authority. The other thing is this woman, we don't know if she may be completely mentally capable and just needing support and assistance. That may not come to the designated agency's attention, right? Because she doesn't meet the mandate. So it could go a few different ways with that example, but I think the important thing is to get everyone to feel more comfortable in asking some of these questions, because in that moment may be the time that you can offer the most valuable support to the person and get help, waiting a day or something. Because the other thing, the quick example, is you need information to keep someone safe in the moment.